board meeting of the city of Evanston. The first thing I'd like to do is a call to order. So we're going to go ahead and convene this meeting. It's a little after 8:30 a.m. on August 14th, 2018. The Electoral Board, just so everyone knows, is comprised of 3 members: the mayor of Evanston, the senior alderman on the city council, and the city clerk. So I'd like to just take the roll. We have all 3. All 3 members are here. All right, so we have a quorum. What brings us here today is we have a referendum that has been proposed to be put on the ballot for November 6th this year in regards to the Harley Clark Mansion.
This is the original.
Okay. Thank you. So everyone is on the same page. The certificate of filing was filed with the city clerk, and the proposed referendum would read, quote, "Shall the city of Evanston protect from demolition and preserve the landmark Harley Clark buildings and gardens next to Lighthouse Beach for use and access as public property consistent with the Evanston Lakefront Master Plan at minimal or no cost to Evanston taxpayers?"
And for the record, this is the original petition and the signatures.
Okay, thank you. And that's a good segue into whether there's a move of this board and members of this board to appoint Michelle Mason-Cup as the counsel to the board for this hearing.
Second.
I'd make the motion on it.
Okay, all right, so all in favor for Michelle to be the, Ms. Mason-Cup to be our counsel, passes 3-0 from this board. There are a set of rules that govern these procedures. Each of the members have those rules of procedure. Is there a move to adopt these rules for our proceedings?
I so moved.
One second.
I second that.
Okay, all in favor?
Aye.
Okay, any opposed? No. Okay, so the rules of procedures have been adopted for this case number 18-MOEB-EV-01. So I mentioned the certificate of filing and all the petitions that have been filed. There was an objection to that. That was submitted by Herbert Harms. It's very short. I'm going to read the objection so everyone here understands it. The measure to put forward to preserve the Harley Clark building should be denied because of false claims that those actions are consistent with the Evanston Lakefront Master Plan. City historical records do not validate those claims. Records clearly show that any City of Evanston plans for that property were for lakefront parkland only. Herbert Harms. So that was the objection. Again, I read the proposed referendum language. Before we have each of the parties get up and present their case, City Attorney, what is the rules in terms of the procedures if anyone would like to videotape these procedures or FaceTime someone in? I know that the filing itself was submitted by Allie Harned, who could not be here. And there's questions whether she can.
Sure. Well, under the
these.
Illinois Open Meetings Act, members of the public can record the proceedings.
Okay.
So that is allowed.
Okay.
No, sorry.
Let me just, Alderman Rainey has a question.
Go ahead.
There's a statement in the call that indicates that if the petitioner does not appear, that a default judgment could be entered and the nomination papers could be declared invalid.
Sure, and that's a good segue. My understanding is that the petitioner is represented by an attorney. At this time, will both the petitioner and the objector please fill out appearance forms?
Thank you.
For the record, Jeff Smith is stepping up. Mr. Smith, who do you represent here?
I represent Ellison Harnett, also known as L.A. Harnett.
You got to fill this out.
It looks like you have a pen.
Yeah, I'm good.
Okay, but on the,
Or more technically, the proponents of the referendum petition, for whom Allison Harnett was listed as the, quote, principal proponent for purposes of receiving service of process and the call of this meeting.
duly noted, okay.
And for purposes of the meeting, the record would reflect that the original and exhibits will be part of the record. So I'm going to mark, for purposes of this record, the call is going to be marked as exhibit number 1. It's the original call by the mayor, and there was a scrivener's error on the page of the call. The last sentence includes the word candidate. If the board could approve an amendment to have that word stricken
So moved.
and have it read petitioner. So if the mayor, could you strike that and initial it there?
Second.
All right, all in favor, I'll do this. And I'm just writing petitioner. Michelle.
Petitioner, correct.
Ms. Mason, thank you.
What's the date today? It's 14th.
Today's 14th. Thank you. So the board has 2 appearances, one from Herbert Harms and one from Jeff Smith for the petitioner.
Okay.
So both parties have entered appearances.
Okay.
And the second exhibit will be marked as exhibit number 2, the agenda. The third exhibit will be marked as exhibit number 3, rules of the board. The original petition will be marked as exhibit number 4. We will not mark this entire exhibit, but merely the cover page will be marked as exhibit number 4. Mr. Harm's objection will be marked as exhibit number 5. Did you give me back?
Let's see. Thank you. Here's the other.
And I'm tendering copies of the rules of procedure to both the objector and
So just on the item of recording these procedures, it is allowed and people can
Correct.
record these. Okay, very good.
and then under the rules, both parties get 10 minutes.
Okay.
And then the objector could reserve time for rebuttal.
Okay.
So if you want to open
And
the
can
case.
and if the board has any questions after they've given their statements, can they engage in questions?
Then the board, yes, you can engage in questions, and then the board would deliberate after that.
Okay,
After the
terrific.
close of the case.
All right, terrific. Okay, so why don't we have the representative of the petitioner, Mr. Smith?
Mayor, do you want to do public comment now or at the end?
Do it now.
You know, we will in the proceedings allow for public comment. What I'd like to do is I'd like to give the petitioner and the objector their, allotted time, and then any questions, and then I'll open it up for public comment.
Very good.
Okay. All right. Okay, so Mr. Smith, representing the petitioner, we will give you up to 10 minutes. And
With all due respect, Mr. Chairman, I believe that is the objector's burden.
It is. The objector goes first.
oh, the objector goes first. Very
Although,
good.
according to your rules, which I searched for online and frankly did not find them, maybe my my search skills are limited, but I'm not sure that they were published prior to this meeting. Motions to dismiss are first entertained, and just for purposes of preserving a record, I would like to make a quick motion and ask the board to dispose of it. I would move to dismiss under rules akin to 2615, first because the election code requires that an objection to a referendum petition be submitted, quote, within 5 business days after the last day for filing of the referendum petition. The last day for filing of the referendum petition was August 6th, and this objection was not submitted within the 5-day period after that. Mr. Harms apparently jumped the gun a little bit and filed before the objection period had started to run. So that's the first objection. And the second objection would be that there's nothing in the election code that gives this electoral board jurisdiction to entertain substantive motions as to the merits of an advisory referendum question. A question of public policy is allowed to be put on the ballot by proponents by filing a petition that conforms with certain specified statutory forms. There's no objection that the form hasn't been followed. This board sits in the nature of an administrative agency, and the courts have treated decisions of the electoral board as akin to those that are reviewed under administrative review. Essentially, what this board is doing is reviewing the acceptance of the filing by the clerk, Mr. Reed, to see whether or not he accepted the petition submitted by Ms. Harned as valid or not. And objections are typically raised as to whether it had a sufficient number of signatures or whether it had the pages numbered, technicalities like that. For larger substantive questions, a court of equity in Illinois is given broad general powers under the law to entertain all sorts of questions and do what is right in the interests of justice and making sure that public rights are protected. This electoral board is a creature of statute and one of very limited jurisdiction, and I would suggest that it does not have the power to entertain a substantive question such as is the entirety of the objection. So that's the nature of my motion to dismiss, and before we proceed to the case in chief, I would ask that you dispose of the motion to dismiss.
All right.
Under rule number 6 for the rules and procedures of the board, motions to dismiss can be provided, but the board may, in its discretion, reserve ruling on the motion to dismiss and conduct the hearing.
I would motion that we entertain Attorney Smith's motion to dismiss based on his second point that the petition does not meet statutory requirements for objections.
Is there a second?
And that we still hear public comment as to any objections, but we do dismiss this case based on the law.
Is there a second? Okay, no second. We'll move forward. Okay. All right, so then we start with the objector. Ms. Missingham?
Yes,
Right.
the objector goes first. They
Okay.
have the burden.
Okay. So, all right, Mr. Harms, welcome. You've got up to 10 minutes to present your objection.
My name is Herbert Harms, and I am an Evanston resident. I do not think the petition to save the Harley Clark Mansion should be placed on the November 6, 2018 ballot. The wording in the measure the group put forward to be on the ballot claims that their plans for the Harley Clark buildings are consistent with the Evanston Lakefront Master Plan. If those words are on the ballot in November, they could influence some voters who might believe them to be true. They may think that it's okay to vote for the building restoration plan if it's consistent with the Evanston Lakefront Master Plan. That false information included in the proposed measure should not be on the ballot to be read by voters who are making very important decisions. Those plans for building restoration that they are proposing on the property at 2603 Sheridan Road are not and never have been in the Evanston Lakefront Master Plan. And to have wording on the ballot that could lead anyone to think otherwise should not be allowed.
Thank you, Mr. Harms. Okay. All right, so now we'll go to the petitioner. And Mr. Smith, you have up to 10 minutes if you need it.
Sure. Thank you, and I respect the contributions of the Harms family to Evanston and the area historically. However, the objection is misplaced. First of all, the statement about consistent with the Lakefront Master Plan is a condition more than a claim in the petition language. The petition could have been submitted saying, we ask that the City Council preserve and restore the Harley Clark Building and Grounds. However, it's actually adding language saying that is, in quote, comma, consistent with the Lakefront Master Plan, comma, is a limiting condition, so that preservation and restoration doesn't open it up to every use under the sun, putting a sports stadium in there, for example. So it's really a limiting condition more than a claim, and that's not sufficient grounds for invalidating it being on the ballot. To the extent that this board, however, feels that it is an affirmative statement that accompanies the first clause, the objection is inaccurate. The Evanston Lakefront Plan was adopted unanimously by the city in 2008, and it still exists on the city website. I've got a site for it. I'm not going to read it all into the record. I will give it to you on paper. But I will introduce a web page printout from it. Mr. Harms, you have a copy. I ask the electoral board to take notice of the city's own documents, which are published to the public. And in the Lakefront Master Plan, it talks about future renovation projects and the broad vision for the city going forward. If you go to the actual section 3 that discusses lighthouse landing area, pages 90 through 95 of the Evanston Lakefront Master Plan, and there is only one document known as the Lakefront Master Plan. It's put in caps in the petition, and it's well understood by citizens as to what this refers to, in part because the city itself continues to publish it. Pages 90 through 95 specifically talk about preserving and restoring these buildings, the historic buildings, on the grounds. The master plan specifically called for, quote, maintaining and celebrating what are known as the Harley Clark Buildings and Grounds, at that time called the Evanston Art Center. The Harley Clark buildings were listed, as noted in the master plan, as a park with special amenities or facilities, such as the ability to host large community gatherings or events. And the Lakefront Master Plan specifically calls for the property to be used for weddings and a light fair cafe. That's at pages 90 to 91. The city's own RFP, a request for proposal, that was published in August of this past year, 2017, with respect to the Harley Clark property, called for preservation by a nonprofit. And the city's own RFP stated that the Harley Clark buildings were an Evanston city landmark whose continued public use would be consistent, quote, consistent with the 2008 Lakefront Master Plan, unquote. The language in the petition referendum is taken almost directly from the city's own RFP. So unless the city's own RFP was a false and misleading claim, then the petition referendum language ought to stand on its own face. The RFP also called for retaining and protecting the historic character of the buildings at the Harley Clark site as an essential element. And the RFP came about as a result of the recommendation of two city committees, including the committee that oversees Evanston parks. So the idea that the parks were never to include or do not include in the Lakefront Master Plan the preservation and restoration of the buildings for public use, which is called for in the petition referendum. And the petition referendum does not single out any particular group or agency to do that. The only other limiting condition is that the city not be putting its own money into it at more than minimal cost. And again, it doesn't specify how that could be done. There have been some proposals that have come forward. We all know that. But there could be other proposals. Or the city could revisit some of the previous proposals. So the objection is simply factually wrong, and it provides no basis for invalidating the petition. Purely as a matter of legal argument, the courts that have looked at, there's almost no precedent for invalidating a ballot initiative that's an advisory referendum on this type of grounds. It basically comes down to, I'll skip to a case called Fugazian versus RTA, where the Illinois Supreme Court rejected an argument that a referendum question was misleading, stating that where the topic was, quote, a matter which generated an exceptional amount of attention in the involved area due to, in large part, to extensive news media coverage for a prolonged period, there is very little possibility that any voter could have been misled by the proposition. As the chairman has noted, as others have noted, this has been a matter of public debate for quite some time. There have been many people throughout Evanston who, 3,000 people have signed this petition. Thousands of others have contacted the Evanston City Council, have submitted online petitions. It's been a matter of news media coverage in the Roundtable, Evanston Now, the Chicago Tribune, all sorts of experts have weighed in on it. This is a well-known proposition. Do we want to demolish it, or do we want to preserve it for public use? So what the Fugazian case, what the Illinois Supreme Court says, that referendum proposition is sufficient, quote, if it presents the proposition in such a manner that the voter has an opportunity to express his choice either for it or against it. And that's been applied by a number of other courts since. So there's really no good precedent for invalidating a ballot like this. In a recent case in Niles, the court ruled that it's not the role of the Electoral Board to review the wisdom of a referendum proposition, and that policy arguments, and this is really a policy argument, are to be directed to the voters. By a policy argument, I'm referring to Mr. Harms' objection. So we've got adequate evidence in the city's own record that, and I ask that both the Lakefront Master Plan excerpts that I've tendered and the printout from the webpage be admitted into the record. We've got adequate public record that preserving the buildings and grounds for public use is in fact consistent with the Lakefront Master Plan. And there's nothing on the face of the petition that suggests that any voter would have difficulty understanding whether they want to be for it or against it. And the courts have also said that in questions like this, it's very easy for the voters to go and do their own research or ask other people, and that can be part of it. This isn't like a constitutional amendment where the proponents are required to have a long paragraph in favor of it, and then the opposition argument is published. This isn't like that at all. It's an advisory referendum. Even if it passes 99-1, the city council could decide we don't accept the electorate's advice on this matter of public policy. It's simply taking the pulse of the electorate, and that's why there's very few, if any, cases invalidating advisory referendums, because it's just letting the people have their say. And let me point out that the city is on record as stating that it has a strong policy in favor of public access to the ballot, and will ignore even, quote, minor irregularities that are submitted in petitions in order to let the people have their say, even if it's incorrect statements made to the general public, because it's just citizens who are petitioning for something. Therefore, the petitioners in this case, one of which is Ms. Allison Harnett, but there were 3,000 others, ask that this board reject the objection and that this matter be certified for placement on the ballot for the November 6th general election.
Thank you, Mr. Smith. We're not, we're going to let these guys, and then we'll have
Do
a
I-
chance for questions.
He has a
Oh, okay.
rebuttal.
Yeah, I just
Mr.
want
Holmes.
to mention that there's a lot of, there's a lot of facts and history about the plans for the lakefront. Just right here is a park plan from 1939. Shows where the property, which is the Harley Clark property, which, here's the lighthouse property, and right next to it, of course, was supposed to be, it was planned to be, planning to be
Proposed parks.
public parks.
With due respect to Mr. Harms, I'm going to object to that as irrelevant because the petition language specifically refers to the lakefront master plan.
Well, that's a master plan back from 1939, and this committee plan, here's one from 1962, an annual report from the Evanston Park Department. And let me show you what it reads in here.
My objection.
The city of
Yes.
Evanston.
It's noted.
The city of Evanston, this is in 1962. It starts out, says, Mayor Bartlett's words had great wisdom. He was talking about having parkland in Evanston. And then part of this paragraph says, the city of now that a scarcity of land has been brought about through development, the city of Evanston must turn to a second phase of acquisition, that of purchasing and tearing down some of the existing buildings. The needs for parks and increasing and are multiplying in our complex society with its lower work hour week and increased leisure time is developing. This is from 1962, from the Evanston Park Department. So there's much in the history. I've got something that goes all the way back to
We're supposed
1970,
to be limited to the
101 years.
To the objection. Okay.
to the text of the objection.
Mr. Harms, we
He's
have to.
getting off course.
Yeah, we can't get off course. We have to stick with the text of the objection
Okay.
as you submitted it.
Which includes the lakefront master plan and these documents, it sounds like are not concerning the lakefront master plan.
Okay, okay. Let me go to the members up here, and then we'll also Clerk Reed, and then.
Yes. Do you have a copy of the legal precedent that you...
Yes, I'd like to tender this.
And Mr. Harms, if I may ask of you, do you have any legal precedent to present to this board that would show why we should accept your objection? Is there any legal precedent that you, or are there any cases that you can point to that...
No, only that historical records show, like I said here, the Evanston plans have been for many, many years to develop open parkland on the lake shore. So that's been a plan for many, many years, and so it's just part of history, and
Mr. Chairman, I also have an tender to Mr. Harms. This is an excerpt from the RFP that I referred to, and I'd like to introduce this as part of the record as well. Again, a city document. This is taken from the packet.
Mr. Chair, do you have any objections to these exhibits that seek to be entered into the record? A series of papers have been passed out. Does the board have any objections to these exhibits?
I have no objection to these being.
So,
I don't know what they are, so
Right.
I'm neutral on it. I haven't read them.
Okay.
I don't know.
I would say that this board, I do have an objection. I think this board has no jurisdiction to discuss policy, as Attorney Smith has stated. I think that, again, I will make a motion after hearing this case that the board dismiss this objection in its entirety, and that, I would recommend that the objector, I appreciate the objector's efforts, but I think the objector should take this case to the people and make the case to the people as to why they should vote against this referendum, and this board has no, again, jurisdiction to hear this objection based on.
Okay. Personally, I want this hearing to, run its course, and I want to hear from the people in public comment and everything else before I make a decision.
So for purposes of the record, I've marked Mr. Smith's brief response to the objection as exhibit number 6, and then a group exhibit for the Lakefront Master Plan, the Lighthouse Beach Lakefront Master Plan exhibit, and the page 17 from the RFP. Those will all be marked as group exhibit number 7. Okay, please proceed.
Okay. All right. Alderman Rainey.
Well, first of all, in all of this paperwork, and I brought the information that we were served with me, but I don't have a copy of the objection.
Mr. Harm's objection?
Yeah.
You have it, the original.
I don't have a copy of that, and I don't have a copy of the referendum wording. Did anybody else bring that?
Michelle.
Second of all, it is my understanding that there are 2 other objections that we're going to be considering at a later date if the mayor is served with them.
That's correct. He hasn't been formally served, I think.
But they in fact exist.
Yes,
and they
yesterday
were
afternoon.
legally provided.
Within the time period, right. Yes.
So we're going to meet again on the August 22nd or something like that?
Well, that was the contemplated continuance for this hearing, if you needed it.
Okay, all right. So since we have other objections, we need it, right?
Well,
Not
the
August.
timeframe for the second set of objections needs to be heard after the mayor formally receives it. We have 24 hours to call it, and then we have 3 to 5 days to meet.
So whenever that date is, there is definitely going to be another meeting.
Yeah.
Definitely. Probably Friday, or Thursday or Friday of this week.
So since, unless you all just go like this and absorb information, I'm going to suggest that we not dispose of this objection today, that we take the time to look at this information and group all of the objections and deal with them all in the same meeting at the next meeting.
Okay.
That's a suggestion. If you would.
Further deliberate at the next meeting. Okay.
Because
Yeah.
Okay, so what I'm going to do now is there anyone here that would like to speak at public comment as part of this hearing? Okay, I see one hand. Okay, so come on up. If you can keep your remarks to 2-3 minutes, I'd appreciate
Okay.
it.
I'm Tricia Conley. I was one of the petitioners for the referendum. And some things you may want to know is that, I don't think it was unusual the way I went about it, that others probably did the same thing. And that was kind of a unified front. And that was that when we approached people, it was like, there's a referendum for the ballot. You're not making a decision here. You can decide. It's the people's voice, the people's choice. Do you want to save this building? Do you not? And, 8 out of 10 wanted to sign. I will tell you, some of the people that did not want to sign actually said to me, I don't want to sign because I think this is going to pass. The public will to save this building is strong, and you guys need to know that. I also want to say I'm very concerned that 2 of the people reviewing these objections clearly have stated in public that they are against this building. So I'm wondering, what is the formalities on recusing oneself in reference to this type of setting? Thank you.
Thank you. Okay.
There's another public comment.
Oh, do you want to, Jennifer? Sure.
I would just like to voice my objection to the continuance on this particular objection. I feel very strongly that the 3 referendum objections are 3 separate matters for 3 separate hearings. The fact that 2 of them were submitted yesterday in the 11th hour means that yes, once they're delivered to Mayor Haggerty, they need to be heard within 3 to 5 days. I understand that. The continuance on this issue, which is a very simple issue according to the facts which you've received, it's obvious in the lakefront master plan, it's obvious in the RFP that the city issued. Continuing that is simply a means, I'm not exactly sure of what, but it should be a very simple dismissal, and I request that you do not continue this particular objection.
Thank you. Alderman Nguyen. Sure.
Thank you. Melissa Nguyen. I agree that that these matters should be really heard distinctly, and that continuing the hearing would, I think, inadvertently cause the board to blur the arguments that are presented actually separately in each of these objections, and that they should be disposed of individually and not amalgamated, because they're not presented as an amalgamation. They're presented as individual objections. So I think the board should rule on this one and then rule on the others individually as well.
So could I ask Alderman Nguyen a question?
Can we?
Would you prefer then that we just accept the testimony of those arguing in behalf of this objection and not read? I mean, I know that you're much smarter than I and that you recall every word in the 2008 plan, but I'm a little older than you and I can't remember, even though I voted on it and supported it. But I'm very interested in these cases, and I am not an environmental lawyer like you are, and I would like to read some of this information. And so you think that I should just make a decision based on what I've just heard and not based on the facts? I really do study my packets and things, and I have no idea if he's telling me the truth or sort of bending it or exaggerating or underestimating. I would really like to read this. He might be exactly right, but I don't know that. So you would prefer just accepting it?
Alderman Rainey, I know how smart you are.
Yes or no? No, I'm not.
And I think that the materials that Mr. Smith has presented are very, very straightforward, and the language is very, very clear. And I believe that this is a very straightforward argument.
And you're familiar with the Supreme Court case?
No, but I heard what he quoted, and I think that it's pretty clear that the Illinois Supreme Court supports advisory referendum because it offers the community an opportunity to speak their voice. And this is not a complicated referendum, as Attorney Smith explained. This is not a constitutional referendum. This does not require a rebuttal. During my time here in Evanston, we've had several advisory referendums. It was that Northwestern should pay its fair share of taxes.
And I supported it 100%.
And what did that mean? There was not a lot of explanation about that, and it went forward. So this is a very simple referendum language, and I don't think that it's complex. And I think that the supporting documents are fairly straightforward as well. But I really do believe that these should not be amalgamated into a single hearing with a single response. They really should be heard separately. And you've just heard the arguments. This is advisory. I think that, as Mr. Smith pointed out, less than a year, or whenever it was, a year ago when we were all here, the board said that it would not, it would let the people, give the people the greatest opportunity and not become a technical board.
Thank you. Okay, so has everyone spoken at public comment that would like to speak? Okay, then You want to speak, Jill?
Just briefly.
Okay.
Speaking is not my foray. Behind the scenes person. My name is Jill Zorn. Excuse me. Not a in front of the scenes person, but just to reiterate what you said, I also collected petitions for the referendum. I had no confusion about the language of the referendum. I had no confusion about specifically the reference to the Lake House Master Plan. I had many discussions. Some, again, because I'm an introvert, were a little bit outside of my comfort zone, speaking with fellow citizens. But I can reiterate what was stated here already, that I encountered no confusion about the language of the referendum. And that was both in support of the referendum, in support of demolishing and not in support of demolishing, because I did have conversations with people on both sides of the fence that were still supportive of the city moving forward with the referendum.
Thank you. Okay, so that concludes public comment. I'm going to open up the discussion amongst the board members on this matter. Okay, see.
Well, I'd like to know about the challenge to the objection of Mr. Harms. It would appear that the clerk's office accepted it, and I'd like to know the validity of that objection.
I'm sorry?
No, I'm talking to the attorney.
Whether or not it's a false and misleading claim.
No, whether or not the objection to the validity of this objection is valid.
Well, the way that it's phrased, it looks like the condition is that it follows the lakefront master plan.
The timing of the receipt.
Oh, the timing. The clerk can probably speak to when it was received, but basically the mayor formally received the objection. The mayor formally received the objection, personal delivery by the clerk on August 9th, and this hearing is within the statutory time period on August 14th.
But the objection said that Mr. Harms submitted the objection ahead of time prior to the legal period for submitting. So
Before it was open, before the filing period. I haven't looked into that issue, but I certainly will.
But the clerk's office accepted because it's stamped
Right.
and everything.
Right.
So it was the assumption of Mr. Harms that his objection was validly received. I'm assuming you did.
So if I may chime in, there are several arguments that the petitioner makes as to why this objection should be dismissed. The objection that I agree with is that this objection does not state a legal reason for this referendum to be removed from the ballot. That is the one that I'm hanging on. He listed two reasons for this board to dismiss the objection.
So it was the non-substantive.
It was the non-substantive.
Mr. Smith raised two things. One was the period in time in which it was submitted, asking that it be dismissed on that. The second one was that it was non-substantive and cited. Okay. All right. Any further conversation?
Well, one of the statements made, and just to clarify, that we wanted to preserve the art center and do everything we could. That was in the plan. And this building is no longer the art center, so I think that needs to be pointed out. It is a vacant building that is deteriorating every single day, so it's not the art center anymore.
I do want to clarify that, again, that this board is to hear legal objections as to whether this referendum should appear on the ballot and not discuss the policy and not discuss policy.
No, we're discussing everything. Everybody else does.
Sometimes it's hard not to when people, public comment, everything else, say all sorts of things that you want to make a comment to. All right.
But that is true, limited to the jurisdiction of the board,
Yes.
not the greater policy discussion.
Right.
I was trying to find the Cook County calendar that the clerk had listed, and I'm just having difficulty finding it.
Well, the clerk had a little trouble finding the calendar also because there was a invalid listing on the city calendar about when this meeting was, which was last Thursday at 2 o'clock, so.
Well,
And also, people were being told the deadline for submitting objections was a couple of days before the real deadline. So everybody was a little confused, and, you know, so.
These hearings don't occur that often.
Yeah.
And there's a whole different set of
Yeah.
rules that apply to them.
So
Okay.
we're all in this
All
boat
right.
together.
There was a lot of confusion because they called me twice from there to try to set up, they didn't know what date it was going to be. So
That's what I'm
there
saying.
was a lot of
Right,
confusion.
exactly. Okay, all right. Is there any further discussion, or would anyone like to make a motion?
I would like to